Swale, good morning.
Good morning.
CMCA, respected friends and relatives and neighbors, it's good to be with you this morning. I want to start by recognizing and thanking our Coast Salish relatives for having us here in their territory. And also to recognize and thank the conference organizers who have worked hard to put this together. I appreciate the opportunity to spend a few minutes with you this morning to share a few thoughts. I was asked to speak on the topic of can international law move Canada towards reconciliation. And last night, my good friend and colleague John Burrows spoke, and I want to kind of take that a little bit further in terms of the issue of reconciliation. So let's see if we get this going here. Okay, so when we talk about reconciliation, we hear a lot about this word, and it's been used quite extensively lately in terms of the relationship between First Nations people, Indigenous peoples, and the government or the state of Canada. So some of the definitions that I found is the action of making one view or belief compatible with another. A way of making it possible for ideas, beliefs, needs, etc. that are opposed to each other to exist together. A new and friendly relationship with someone who you argued with or fought with, to restore to friendship or harmony, the restoration of friendly relations, or to settle and resolve. So those are some definitions of this word that we use, reconciliation. So what is it that really is what are we trying to reconcile? So I'd like to suggest that the origin of these opposing positions, and the opposing positions is really what I would think needs to be reconciled. So in 1550, so this has been going on for a long time. In 1550, there was a debate that took place in Spain, and it set out the issue in the form of these two questions. First question, whether the Indigenous peoples of the Americas were capable of self-government. Second question, were the Indians of the Americas capable of ownership of property? And those two questions continue to be at the center of the debate. They continue to be the key issues that we have to find this issue of reconciliation. It all centers around those two questions. So when you think about Indigenous, First Nation relations with the government of Canada, with the people of Canada, I would suggest that this really is at the heart of it. You hear a lot about policies and government actions that have taken place, and I would say that those really center around this issue of are our First Nations people capable of governing themselves? And we're going to go through a little bit about some of the attitudes that have existed. So I want to start with talking a bit about the foundation of European nations' policy of denial, the beginning of what we now call international law, and something that is referred to as the doctrine of discovery. Again, this started a long time ago. This happened, in 1095. But back, that long ago, there were attitudes that were being formed, and I suspect it goes back even further than this. But for the purposes of our discussion today, I'll go back this far. There was a belief that was put forward, and it was put forward by the church, by Pope Urban II, and he issued an edict, a papal bull. And this papal bull was terra nullius. And basically, terra nullius was empty land. And the thrust of this papal bull was that it gave kings and princes of Europe the right to discover or to claim the land of non-Christian people or areas. So this was the foundation of a belief that we'll see has carried on. During that time period, there was a debate, as I say, that took place. This was one side that was being argued. This Spanish theorist, theologian, Subavida, reasoned that the Indians were a barbarian race whose nature, inferior condition entitled the Spaniards to wage war on them. As Subavida put it, being slaves by nature, the Indians, uncivilized, barbarian, and inhuman, refused to accept the rule of those civilized, that is the Spaniards, with much more power than them. So this was one concept that was being put forward. Adam Smith, economist, philosopher, English, I guess at least from that area. I don't know if the English would agree that he was English or that he would like that. But anyway, he put forward these ideas as well, that the savage state is the lowest in society and the Indians of America are the most retrograde form of society. He said the governments of the savage nations of the Americas are unsophisticated and weak, lacking any form of private property, and there is also no property among them. So these attitudes that were established during this period of time. The doctrine of discovery then. A good friend of mine, Professor Williams at the University of Arizona, gave a presentation in New York recently at the United Nations. And this is what he had to say. He said, without question, the doctrine's most important principles, its central animating idea, is the principle of extinguishment. This doctrine of extinguishment will typically originate in the language of racism and religious and cultural intolerance, which regards indigenous peoples as savage, backwards, and inferior, and therefore an obstacle to the progress and development of a superior form of civilization, the non-indigenous nation state. Under this principle, the colonizing state asserts the power to extinguish indigenous people's property rights in their traditional lands and the rights to self-determination in those lands. Under the doctrine, the state has the power, in essence, to extinguish our languages and religions and even our existence by recognizing some and not recognizing other indigenous peoples as being indigenous. So you can see that in the Indian Act in Canada. What has impacted and continues to impact indigenous nations and peoples is not so much the idea of discovery, but the centuries of treating the domination and dehumanization of originally free nations and peoples as legitimate. The doctrine of Christian discovery and domination refers to the patterns of thought and dogma used to legitimize the domination of originally free and independent peoples, nations and peoples. So I want to go forward now and talk a little bit about this concept of extinguishment. And I want to talk about it in the context to begin with in terms of judicial decisions and political positions. So early on in the 1800s, there was a case that was brought before the Supreme Court of the United States, and it involved the Cherokee people. And the Chief Justice of the United States had some statements that he made, and this was the beginning of establishing this domestic policy or the law that has led to this policy of denial that we see carries on today. And you'll see the connections between Canada and the United States in a minute. So Chief Justice Marshall said, "The character and religion of the New World's inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. To leave them in possession of their country was to leave the country a wilderness. Agriculturalists, merchants, and manufacturers have a right to expel hunters from their territory. Excuse, if not justification could be found in the character and inhabitants of the people whose rights had been wrestled from them. The rulers of the old world made ample compensation to the inhabitants of the new by bestowing upon them civilization and Christianity." Supreme Court of the United States. By denying the Indians ownership rights in their lands and reducing their status from owner or true owner to occupants, Marshall disregarded accepted principles of law of nations. Marshall further deviated from the law of nations in his treatment of title by conquest and the obligations of successive sovereigns to the conquered. So you'll see as I go through this how he has ignored principles of international law that existed even at that time. So the real conquest was on paper, on maps, in laws. What those maps showed, what those laws said, is that the Indians had been conquered merely by being discovered. As put by Chief Justice Marshall in the case of Johnson and McIntosh, however extravagant the pretense of converting the discovery of an inhabited country into conquest may appear, if the principle has been asserted in the first instance, if a country has been acquired and held under it, it becomes a law of the land and cannot be questioned. You're going to see how this is relevant here today. Move forward a little bit, we see that the Supreme Court of Canada jumped in on this. The Supreme Court of Canada, in a case called St. Catherine's Milling, adopted John Marshall's reasoning, adopted that American law. And this is what they had to say. They said, Indians at the time of discovery were nomadic barbarians, or heathens and barbarians, who lacked any proprietary title to the soil. In support of this, Boyd, the judge, cited a 1675 legal opinion in which eminent English lawyers declared that the discovery of barbarian lands gave the discovering nation the right of soil and government of place. He then asserted that in Johnson and McIntosh, Chief Justice Marshall had concisely stated the same law as the mother country, which the United States inherited and applied with such modifications as necessitated by the change of government to their dealings with Indians. So we see that the Supreme Court of Canada followed the United States Supreme Court in the 1800s. This was appealed to the Privy Council. The Privy Council upheld that decision. Lord Watson, on behalf of the Council, objected the notion that the Ojibwe had been owners in fee simple of the territory that they had surrendered. Instead, held that the Crown had all along had a present proprietary estate in the land upon which the Indian's title was a mere burden. Rather than constituting an ownership right, the tenure of the Indians was a personal and use right dependent on the goodwill of the sovereign. So we see that this principle of discovery is now part of the domestic law of Canada. And since then, the Supreme Court of Canada has followed that decision. Calder, 1970s, Supreme Court of Canada, land claim case by the Niska. Supreme Court of Canada, on discovery, the Aborigines are considered to be rightful occupants with a just claim to retain possession and use but their rights to complete sovereignty as independent nations was necessarily diminished, and their power to dispose of the soil on their own to whomever they pleased was denied by the original fundamental principle that discovery gave exclusive title to those who made it. Go forward, Supreme Court of Canada, another well-known case, Garin. They refer to Calder, and they refer to Chief Justice Marshall, and they refer to St. Catherine's Milling, and they conclude by saying that Indians have a right to occupy, but the ultimate title is in the Crown. And their interests do not, strictly speaking, amount to a beneficial ownership. And they then begin this concept of calling it sui generis. Move forward to Sparrow, or let's see, that was Sparrow. Oh, okay. I guess I should go back. Sparrow. It is worth recalling that while British policy towards the native population was based on respect of the right to occupy their traditional lands, a proposition of the Royal Proclamation of 1763 bears witness, there was never from the outset any doubt that sovereignty and legislative power, and indeed the underlying title to such lands, vested in the Crown. And again, they refer back to Johnson and McIntosh and Chief Justice Marshall's decision. In Delgamuukw, they again refer back to St. Catherine's Milling. So Delgamuukw is in the 1980s. And talk about that case and how that still is the law. In a case from the East Coast dealing with the Mi'kmaq, the Marshall and Bernard decision, Madam Justice Lavelle talks about that case, and she concludes by again going back to St. Catherine's Milling. So we can see that in the Supreme Court of Canada, there has been a long line of decisions that go back to this underlying concept that started out in the 1500s and was carried on and continues right through to today. In the Chilcotin decision, the BC Supreme Court, or BC Court of Appeal rather, just a few months ago, made this decision. And they have this to say. They say the basic concepts underlying claims of Aboriginal title and Aboriginal rights are straightforward. First Nations occupied the lands that became Canada long before the arrival of Europeans. As the trial judge noted, Aboriginal nations were not recognized as nation states by European nations colonizing North America. European explorers considered that by virtue of the principle of discovery, doctrine of discovery, they were at liberty to claim territory in North America on behalf of their sovereign. Then the court says this: while it is difficult to rationalize that view from a modern perspective, you kind of hear John Marshall here, right? The history is clear. As was said in Sparrow, while British policy towards the native population was based on respect of the right to occupy, there was never any doubt that sovereignty and legislative power, and indeed the underlying title to these lands, vested in the Crown. 2012. They go on to say, there is a need to search out a practical compromise without unnecessarily, that can protect the Aboriginal traditions. Okay, they don't talk about Aboriginal ownership or Aboriginal anything, they talk about their traditions without unnecessarily interfering with Crown sovereignty and the well-being of all Canadians. As I see it, an overly broad recognition of Aboriginal title is not conducive to these goals. And then the court goes on and says that in the Chilcotin case, that the Chilcotin people and First Nations people are not able to claim title to their territories. That they can only claim title to places that they can prove they had extensive use and occupancy. And they refer to rocks that you stood on when you fished, or salt licks. I'm not sure how salt licks got into the equation, or buffalo jumps. So clearly there's a problem. Clearly there's a problem in our justice system. And we can see this long line of thought, this long line of reasoning that goes back to the 1500s. And it starts with this thing called the doctrine of discovery. In another case, Regina versus Silboy, they said this: the Indians were never regarded as an independent power. A civilized nation first discovering a country of uncivilized people or savages held such country as its own until such time as by treaty it was transferred to some other civilized nation. The savages' right of sovereignty, even of ownership, were not recognized. They say this: Nova Scotia was conquered by Nova Scotia was passed to Great Britain not by gift or purchase or even by conquest of the Indians, but by treaty with France, which had acquired it by priority of discovery and ancient possession. And coincidentally, the Indians passed with it. In this, in the Mi'kmaq Tribal Society versus Canada before the United Nations Human Rights Committee, this was an argument. International American and Canadian law do not recognize treaties with North American Native people as international documents, confirming the existence of these tribal societies as independent and sovereign states. These treaties are merely considered to be nothing more than contracts between a sovereign and a group of its subjects. So these are the positions that are being argued before courts and before international bodies. You know, this attitude has been expressed by political leaders. We all, probably a lot of you, I know a lot of you here, you've heard, of course, Joseph Trutch, first Lieutenant Governor of British Columbia. This was his statement. He says, I think they, that is the Indian people, the Indigenous First Nations, are the ugliest and laziest creatures I've ever saw. And we should as soon be afraid of our dogs as of them. And he says, the Indians have no right to the lands they claim, nor are they of any actual value or utility to them. I cannot see why we should either retain, they should either retain these lands to the prejudice of the greater interests of the colony, or be allowed to make a market of them either to the government or to individuals. And I kind of hear the BC Supreme Court there, you know, the same kind of reasoning. You know, we have to balance these things, and we can't do it to the prejudice of all Canadians, right? So same kind of logic, same kind of reasoning. Prime Minister Harper made this statement. You know, Canada has no history of colonialism. So this is reflective, I think, of again, this pattern of thought, this pattern of ideology, if you want to call it that, or positions, or you know, some might even call it racism.
Yep. Yeah.
So what was Canada's original position on the United Nations Declaration on the Rights of Indigenous Peoples? They said, Canada's position has remained consistent and principled. We have stated publicly that we have significant concern with respect to the wording of the current text, including the provision on lands, territories, and resources. Free, prior, and informed consent when used as a veto. Self-government without recognizing the importance of negotiations, and the need to achieve an appropriate balance between the rights and obligations of Indigenous peoples, member states, and third parties. Again, you hear a similar kind of a theme running through these statements. It all goes back to this debate, this very fundamental debate. What are the rights of Indigenous peoples to land? What are the rights of Indigenous peoples to the resources? What are the rights of the Indigenous peoples to self-determination? And Canada continues with this position. They say that the Declaration is an aspirational document which speaks to individual and collective rights of Indigenous peoples. The Declaration is not a legally binding document. It does not reflect customary international law nor change Canadian law. And that's what we see. We have brought a case before the Inter-American Commission on Human Rights in Washington, D.C., and this is what Canada has argued. This issue has been dealt with by another country, Australia, in a case called Mabo. And in the decision of Mabo, this is what the High Court said. The idea that land which is in regular occupation may be terra nullius, or empty, that is, there's no people living there. And the reason they say there's no people living there is because they are so retrograde, so savage, that they are not people, they are not human. So I say that terra nullius is unacceptable in law as well as in fact. Even the proposition that land which was not in regular occupation may be terra nullius is one that demands scrutiny. There may be good reason by why occupation is irregular. Think about what the Court of Appeals said in British Columbia in Jacobi. The theory that the Indigenous inhabitants of a, quote, settled colony has no proprietary or property interest in the land, thus dependent on a discriminatory denigration of Indigenous inhabitants, their society, or their social organizations and customs. As the basis of the theory is false, in fact, and unacceptable in our society, there is a choice of legal principle to be made.
Yes.
And that's where we're at. That's where we're at in Canada. Talk a little bit about that. But there is a choice of legal principle to be made. They go on to say, the fiction by which the rights and interests of Indigenous inhabitants and land were treated as non-existent was justified by a policy which has no place in the contemporary law of this country. The expectations of the international community accord in this respect with the contemporary values of the Australian people. And I would hope we could say the same of the Canadian people. That, you know, these policies that are based on these old thoughts and dogmas and beliefs of the 1500s have no place in our current courts. It has no place in our current politics, and we have to find a way to root it out. During that period of time, there was another part of the debate that was taking place, and it was led by some other Spanish theorists and theologians. Francisco de Victoria, at this, he introduced the topic of Indigenous people's rights into the dialogue of international law in 1532 on a lecture that was called On Indians Lately Discovered, and central to his philosophy was that certain rights adhere to men as men by reason of their humanity. And so this was out there. This was being discussed back then, and it's been there all along. But it was rejected, by the court. Rejected, I suspect, by the politicians. That this notion of human rights, that Indigenous peoples have rights because they're human, because they are men, and that needs to be respected. So in this Indigenous human rights era, one of the writers, Reisman, makes this opinion that the original phrase decolonization was really a demand for law and human rights, and it was a call for the universal emancipation of the colonized. But maybe it doesn't apply to Canada because Canada has no history of colonization. And this is based on recognition. So we can ask these questions. Can human rights and international law restore to friendship or harmony the relationship in Canada? Can it lead to a restoration of friendly relationships? Can it help to settle or to resolve these major differences? You know, this major question of what are the rights of Indigenous peoples? What are the rights of Indigenous peoples to land and resources? And what are the rights of Indigenous peoples to self-determination? The Inter-American Commission has put forward some thoughts on this, and they've put out an excellent publication where they've gone through international law and have boiled it down to a few basic statements. And so they talk about the content, the specific content of Indigenous or tribal people's rights over lands. You're going to have to watch. Okay. So, what is the extent? And they say that the extent is as broad as the special relationship that Indigenous peoples have with the land. That's how broad it is. So they come back and they say, well, if you want to understand, you have to understand the Indigenous people's relationship to the land. And what is the importance of that relationship? And that will define how broad this content is. It's not, the rock that you stood on when you went fishing, or the cliff that you chased the buffalo over, or the specific place where you had a village. It was as broad as the relationship that you had with the land. They talk about full ownership, more than a mere privilege or interest, more than a sui generis right of occupancy, more than the right to use the land. Because after all, if Indigenous peoples have the same human rights, the same right to equality, should they not have ownership? Or is that simply reserved for a few? They have a right to recognition, a right to have their titles to their lands recognized, a right to have their titles to their lands registered as a legally recognized interest. In British Columbia, what we hear is, well, First Nations have been litigating and going to court, and they won these cases, but the cases never really make a conclusive finding. But we can no longer deny that there's absolutely no interest, because that's what the government's position was. There's no interest in the land by First Nations. That was defeated. And now the thing is, well, we don't know where. You see in Chilcotin, we don't know where the Chilcotin people's interest in the land is. Even though the Chilcotin were on the stand for probably, I'm not sure how many months, giving evidence about their historical use and occupancy of their territory, the government says, well, we don't know where. And you have to prove it before we're going to recognize it. And so there has been no recognition. And here we are in 2013. How many years has it been since the 1500s? And the debate still rages in British Columbia about what are the land rights of the First Nations people in this province. And you still have politicians and you still have courts taking the same position that John Marshall took, taking the same position that our good friend Joseph Trutch took, in those early days. They say that legal certainty of property title, that we need legal certainty of property title, that it is that there's a non-disposable nature of the right, that there's a prohibition of depriving, and a prohibition against reduction or modification of the title without consent. Now, these are some pretty strong words that are being put forward by an international human rights body made up of jurists, made up of legal scholars, who are saying that these are the international principles that should be applied in domestic states like Canada. There needs to be what they call a delimitation and demarcation of ancestral lands. Not salt licks, not rocks that you stood on, but ancestral lands. That the pre-existence of the right vis-a-vis titling, there needs to be a pre-existence of the right vis-a-vis titling, delimitation, demarcation, effectiveness of safeguards from use, their existent limitations in unrecognized territories. It needs to be free of charge. In the BC treaty process, First Nations are at treaty tables, as you know, but in order to fight the fight, in order to retain the people that you need to have, like myself, at the tables negotiating for 20 years, we've set up a system where we borrow money. We borrow money in order to support the process, and that eventually has to be repaid. So First Nations are at the tables negotiating these principles and issues against some very, very firm positions, and they go back, to the 1500s and attitudes, and all the while they're accumulating, debt. A right to the restitution of ancestral territories of total or partial loss of possession, even where there is third-party bona fide ownership. And this is our situation. Those of you that have heard me speak, and I know a lot of you, I've spoken many times about the Hulkaminum position. In our territory, just north of here in Duncan and north to Ladysmith, we're part of that infamous ENN land grant area. And in the 1800s, in order to finance British Columbia becoming part of Canada, they negotiated a deal. Because the province at that time and the provincial leaders at that time wanted the railway brought here to Victoria, they put on the bargaining block 2 million acres of land, a 40-mile wide swath of land from Victoria to Comox. That was used to finance the deal. Dunsmuir and some American partners got the contract, and they built a rail from Nanaimo to Victoria, the ENN, and in payment of that, they got fee simple ownership to 2 million acres. All of the resources, all of the coal and all of the timber. Plus they got, I think it was $600,000. So not a bad deal, for them, but a very bad deal for us. At that time, there was no discussion with the Hulkaminum people. There was no treaty. And when we got to the treaty table in the 1990s, we were told by government, well, that's all private land, and private land is not on the table for negotiation. So this concept that they're talking about here, that even where there is third-party bona fide ownership, and this is what would be argued in the ENN, the large corporate interests, Timber West, Island Timberlands, and others would argue, well, we're bona fide third-party owners. We pay good money for this land. It's ours. And the government of Canada says, yes, we recognize that. You can have legal title to it, and we're not going to disturb that. We're not going to expropriate those lands back. And so what do we do? And what the international law says is there has to be some type of restitution. And so this one very much applies to us. The right to territory as a necessary means for access to exist under conditions of dignity, extreme vulnerability, and disposed communities, multiple state duties towards them. So, this is very much an international document, and of course, in some countries, these are very significant issues for Indigenous peoples. Latin American countries and other countries in the world, access to resources, access to territories, the extreme vulnerability and dispossession of people who are forced out of their lands to make way for development that's happening in other countries. The right to consultation, to consent to participate in matters related to lands, protection from displacement without free consent. And again, not so much now in British Columbia. I think that's something that is not likely to happen. But in other countries, I'm sure that those kind of things still occur for Indigenous peoples. In terms of rights over resources, the Inter-American Commission starts off from the premise of ownership. So it's a very different starting point than we have in British Columbia, than we have in Canada. If you start from the place of ownership, then the resources, there's a much different interest in the resources. And they talk about these three rights: ownership of the resources as a result of land ownership, a right to the integrity of the environment, and there are state duties that flow from that. And then in the Saramaki decision, they have this triple test down here for plans or projects that are being proposed for development or investment in terms of extractive resources. So the international system has really developed some of the principles that are there that can help to counterbalance against those old attitudes. And they're based on human rights. So in terms of international jurisprudence, as I said, there's the American Court, the Inter-American Commission. They've considered a number of cases. The Agostini people brought a case forward in Nicaragua, and the court, Inter-American Court, said that Nicaragua has in fact violated the right to an effective remedy by failing to ensure the enjoyment of indigenous lands that were affirmed by the Nicaraguan Constitution and laws. And so you heard a little bit from Janie about Section 35. In Canada, we have the same kind of a recognition under the Constitution. And I would say that Canada, you could just take Nicaragua out of there and put Canada in there, and it probably would apply. Nicaragua has violated the right to property by granting concessions to exploit resources on Agostini's people's traditional lands and not titling and demarcating these lands in favor of the Nicaraguan people. The right of property includes a collective right of Indigenous peoples to the enjoyment of their traditional lands and natural resources. For Indigenous communities, relations to the lands are not merely a matter of possession and production, but of a material and spiritual element which they must fully enjoy, even to preserve their cultural legacy and transmit it to future generations. This is the kind of thinking that's happening at the international level. The Dan sisters, the Western Shoshone, brought a case against the United States. This is what the commission said. Where property and user rights of Indigenous peoples arise from rights existing prior to the creation of the state, Indigenous peoples have the right to recognition by that state of the permanent and inalienable title of Indigenous peoples relevant thereto, and to have such title changed only by mutual consent between the state and the respective Indigenous peoples when they have full knowledge and appreciation of the nature and attributes of such property. It also implies a right to fair compensation in the event that such property and user rights are irrevocably lost. In the case of the Maya people against Belize, this is what I think was the court said, that the Maya people's communal rights there is a corresponding obligation on the state to recognize and guarantee the enjoyment of this right. In this regard, the Commission shares the view with the court, so I guess this is the Commission, that this obligation necessarily requires the state to effectively delimit and demarcate the territory to which the Maya people's property right extends, and to make the appropriate measures to protect the right of the Maya people to the territory, including official recognition of that right. The Saramaki people against Suriname, again, this is an interesting one. They make this quote. It says, the court observes that all so-called judge-made law may be a means for the recognition of the rights of individuals, particularly under common law legal systems. Canada, this is Canada's argument. Well, First Nations, if you want to have your rights recognized, go to court. Spend millions of dollars that you don't have, and prove it. Prove that you were here. Prove that you were here. The availability of such a procedure does not in and of itself comply with the state's obligation to give legal effect to the rights recognized in the American Convention. That is, the mere possibility of recognition of rights through certain judicial processes is no substitute for the actual recognition of such rights. Canada. That's Canada. They could take Suriname out of there and put Canada in there. The Sohamaxa people against Paraguay. How am I doing? Running out? I'm out of time? I'm out of time. Well, there's this is an interesting one on this issue of people, indigenous peoples who have lost their territories, and how the court says that where there's been this transfer to innocent third parties, that they are entitled to restitution of either lands or some kind of compensation. And this is where we're at. This is our case. We went to Washington, D.C. 3 times, appeared before the Inter-American Commission. In our case, the Commission said that the BC Treaty process is not effective. The state, in our case, has argued that these private lands are not on the table, except on what they call a willing seller, willing buyer basis. And the Inter-American Commission said that the treaty process is not an effective mechanism to protect the rights. And they say, in examining the government's position that if the Hulkaminam do not wish to accept their terms in negotiations, that we can litigate, again you go back to Suriname, there is no due process of law. Interesting comment for Canada. No due process of law. They said that legal proceedings in Canada was arguing, well, look at all these cases. Look at, Sparrow, Delgamuukw. Look at all these cases that Haida. All the cases that the First Nations have brought to court. They say that in looking at all those cases on Aboriginal title, they do not seem to provide any reasonable expectation of success, because Canadian jurisprudence has not obligated the state to set boundaries, to demarcate, and to record title deeds to the lands of Indigenous peoples. And therefore, in the case of the Hulkaminam, those remedies would not be effective under recognized principles of international law. So, there's a lot more that I could say, but I'll end it there. The question, can international law move Canada towards reconciliation? Yes, if properly implemented. Yes, if we can get the courts to understand and to accept that their positions based on Marshall, based on St. Catherine's milling, is absolutely false. It has no legal underpinning. It's based on principles of racism. It's based on, that doctrine of discovery. So, we're hopeful. I'll find out on Tuesday if the Hulkaminam people support the Hulkaminam intervening in the Supreme Court of Canada's case to raise these arguments and hopefully to move Canada to a more just society, to become a more just society, to become a more humane society, to become a society in which human rights are truly respected. You cannot go onto a reserve and not recognize that there are human rights problems. You cannot go onto a reserve and not recognize that something has to happen. And it goes back, I would suggest, to those two fundamental questions. What are the rights of Indigenous peoples to land and their resources? And what are the rights of Indigenous peoples to self-determination? So again, I want to thank you for being here. Thank the organizers. Thank you.